now we have our quorum. This is great. Um, we should go around the respective rooms and introduce ourselves. We have I'm very happy additionally to introduce Kristen O'Neill, who is our new assistant director. This is her third day. And if you'd like to say something, go ahead.
I came from the Office of Mental Health. I worked as a records access officer there, so I have a little bit of experience with information law, not as much experience with open meetings law, so I'm learning. I am trying to get some on-the-job learning.
Well, that's the best one. But I'm really looking at
I'm not hearing you all very well. Is there static or something?
Hold on a second, Frank. I'm going to move the microphone up.
Hello. Welcome to the
it's
conferencing
static.
system. To join a conference, you may use the camera controls on your remote. Please
I
enter the
think you
conference
just cut
code
us
now.
off.
Can you hear us, Franklin?
I can hear you. Oh, now I can see you.
Oh, now we can
Yes.
see each other.
And
We lost
the
Buffalo.
sound is good, but we've lost Buffalo.
Well, I think
Please
Buffalo,
enter the conference code now.
if Buffalo talks, maybe we'll.
We're here. We're
Okay.
here. Oh,
Okay,
Yay. That's
all right,
the-
but
that's the
we should have
switchover.
we should have another screen so we can all see each other.
I think it alternates, depending on who's speaking.
Please enter the conference code now.
This is not.
Please enter the conference code now.
There must be. Candace, can you get our
Yeah.
guys so that we can have both screens on at the same time, which is what we've done in the past.
And the
Please
sound is
enter the
coming through
conference
well
code
now,
now.
except for her. So welcome, Kristen.
oh, thank you. Nice to meet you.
Please enter the conference code now.
So Bob, who else is
Yes.
in New York these days?
Excuse me?
Please enter
Who
the
else
conference
is in
code
New
now.
York on the committee these days?
Who else is in New York? Just Dave Schultz. Just Dave Schultz. We have a vacancy, and I'm hoping that it'll be filled one of these days.
Please enter the conference code now.
Who do we need to talk to get it filled?
Well, I've been in touch with the appointments office, and it's their call. I've even recommended a few names, and I did so months ago, and nothing has happened. Nothing has happened. Candace, are we getting somebody up here? Okay.
Hi.
Okay. We need Buffalo on the screen as well.
The appointments office for what, Bob? Is that the state or
Governor
the
Appointments
Senate?
Office, because this would be a gubernatorial appointee.
That's what we're missing. Okay.
Yeah, we have Steve is our Senate designee, and you are, as you know, from the Assembly, and the governor appoints the rest. I was hoping also to see Peter Grimm. I thought he was going to be here, and he might walk in late. He's our local government representative. The rest, and again, we should, as soon as Buffalo comes on the screen, we should go around our respective tables and introduce one another. Sorry for this delay. It's the technology.
Usually the technology works well.
Yeah, usually the technology works well, but I can apologize, I suppose.
She stopped asking us to sign in. That's a good sign.
Yeah, well, that's a good thing, yeah. Shannon Hadley, are you still? Can you still hear us? 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 Hear
Again.
That was something.
Well, hello, Franklin.
Did you all have screeching?
Okay, yes, we did.
Sorry about that. We were.
I went looking for a tech person, but I didn't
All
find
right.
one.
It looks as though we're all together.
Thank you.
Okay.
All right.
Thanks for your help.
So let us begin going around your table, Franklin.
Okay. My name is Franklin Stone. I'm a retired lawyer. Early in my career, I did a lot of First Amendment work on behalf of newspapers. And all along the way in my career, I've done a lot with law enforcement, including serving a 10-year stint on the Civilian Complaint Review Board in New York City, following a stint where I was a federal prosecutor. I've kind of got my life backwards here now. Any event, this is a subject that is near and dear to my heart. And it's also the most pleasant committee I've ever served on.
Well, thank you. Now let us move to Buffalo.
I'm Jean Hill, and I have a background as a journalist, and I as a compliance officer for M&T Bank.
Great.
I'm Hin. I was an Associated Press reporter and then worked in public relations, both for the private sector and state government.
Great. Thank you. Amy.
Sure. I'm Amy Ottaviano. I am the director of the budgets designee to the committee, and I am assistant counsel to the division of the budget, and I have been serving in that capacity for a little over 3 years now. One of my roles is in that capacity is, dealing with the agency.
I'm Stephen Waters. I'm the Senate designee. I'm publisher of the Rome Daily Sentinel, which is a 10,000 circulation, family-owned daily newspaper in Rome, New York.
I'm Jim Leary. I'm the New York State Secretary of State's designee to the committee. I am an associate attorney with the Office of General Counsel for the Department of State.
Bill Brousseau, I'm General Services, and I am an associate attorney in the counsel's office. Yeah. Come here for a long time.
Long time. Kristen introduced herself. We all know each other. My name is Bob Freeman. I've had the same phone number since 1974, which means that either I've had a great job with the Committee on Open Government or I'm in the biggest rut ever created. My belief is that that the former is the truth. Candace.
Otto, I've worked with the last 6 months.
Thereabouts. Candace has become our right-hand person, and I am more than happy that she is with us. She's put together the annual report. She's done the pie charts. She does all kinds of things that I cannot do. So now we should get to the report and hear your comments regarding the draft.
We have to approve minutes.
We could approve minutes. The last time we met, it wasn't really a meeting.
That's right. Then never mind.
It wasn't really a meeting because we didn't have a quorum, so we had we have minutes from a year ago, which are brief. That was the meeting during which the committee approved the report with a few modifications. If anybody sees fit to move to approve those minutes, you've changed. Bill has changed, yeah. Oh, my goodness. We will make that change. Candace will make the change. Is there a move to adopt as amended?
That's amended.
Great. Any opposition? Let's move on to the draft. As indicated in my little cover memo to all of you, much of the draft consists of reiteration of proposals made earlier. There have been modifications. We're still waiting. We're still waiting for action by the governor regarding two bills that have been passed by both houses. Action, I believe, has to be taken at the end of the year. Otherwise, the bills become the subject of a pocket veto. Some mistaken, which means that they can be reborn again next year. But I would hate to see these bills fall through the cracks. There have been a few editorials pushing the governor to take action, but we'll see what the future brings. My hope is that we will see something before the end of the year. Haven't seen anything yet. Are there comments regarding any of this, including there are a couple of areas which represent something of a change based upon our discussion from a couple of weeks ago. The section regarding 50A, the Civil Rights Law, includes support from other sources, particularly the New York Times and other newspapers. Again, I'd like to think that Franklin, in particular, you'd agree that the time is right for some sort of modification of 50A.
I completely agree, and I thought this was an excellent first draft of our report. I have some stylistic comments that I'll give you. I think we need some stronger topic sentences here and there. But to jump to 50A for a moment, I didn't go back and pull our last report, but didn't we go for either repeal or significant amendment? Because
we did.
I was going to raise that also.
And here we start with repeal, and then we get kind of wishy-washy later on about amendment. And I just think we ought to be upfront about calling, maybe because of the political realities, we do the same thing again this year, which is call for repeal or at a minimum, significant amendments. I think it should be repealed, but, nobody's elected me to public office, so I don't want to overreach.
Well, you talk about overreaching, and that is something that I try to avoid doing, but that's why we have people like you on the committee, so that you can say things that perhaps I could not appropriately suggest. But I think to add strength to this, and it sounds though that's the consensus, that there should be, that the issue should be presented in the way that you described, repeal or, at a minimum, an amendment to 50A. What do you think of the amendment that was proposed?
I think I'd like to go even more than that. Repeal or add amendment. Like we're still pushing repeal. I mean, just either significantly amend or repeal.
You're talking about the body cam amendment?
No, we're still talking about 50A in general.
What was Bob referring to as what do you?
It was just the way he put it. It still sounded like we were pushing repeal over amendment.
Well, I would like to prefer to push repeal over amendment, but I think if we want amendment, we ought to have a specific recommendation of how it could be amended.
Well, that's why I asked on page 6 in the paragraph that begins with the notes. Reference is made to the legislation introduced by Senator Parker and Assemblyman O'Donnell that would amend 50A by referring to personnel records that are, quote, created and used solely, close quote, to evaluate performance. I think that as an amendment, that would be the next best thing to repeal.
Then let's have a topic sentence that introduces that as, if there isn't political stomach for repeal, let's go for amendment.
How would you want it to be presented?
Well, let me move back. Just at the beginning of this section, the very first paragraph, you don't tell people what 50A is. The first time you get to what 50A is at the top of page 6. And I think we need to add a sentence up front to remind people of what the problem is with 50A.
It seems to me that's in bold, right under legislative proposals.
I would have said that would have been a paragraph 2. The A point ought to be, what do you want to do and why? Then you say, then you explain the problem.
It's in bold, but it doesn't explain why that's a problem. Why that's an exception that has been bent all out of shape.
Okay.
A topic.
So you want in the first paragraph below.
Well, and she was putting in the first paragraph. She was putting above as a header.
Or just add it to the paragraph. I just think up front you need to have a sentence or maybe 2 describing what the problem is. Yeah. Because you don't really get to it until you discuss it on page 6.
Okay.
Yeah. If it's above, you're saying we want to do this, and then the immediately before it we say, well, this is what it does now. Tell them why you want to do what you proposed.
There's probably some language from past reports we can lift for that.
Well, I'm sure that's true.
The thing I thought was interesting was that Bill was interested in saying first a significant amendment or repeal, and you were calling for repeal or significant amendment. Bill was saying that he preferred amendment. You were saying you preferred repeal, and I think that Bill's suggestion of language actually, by ending on repeal, is the more powerful statement for repeal.
I just think last year there was not a consensus that we pushed for repeal, but everybody agreed there's something that needed to be done. So I just like to keep it objective still.
So I would agree with Bill's suggestion, but that's because I happen to think it's a more powerful statement calling for repeal.
Well, it may be a more realistic statement.
Okay.
Too. I just think you.
So I'm agreeing with Bill because I disagree with him.
You've heard the phrase
I just
agree
want
to
the language
disagree.
to say.
So then maybe based on what we just heard, the suggestion is acceptable. To describe the problem, why we need it, and to recommend amendment or repeal. Amendment or repeal. And my assumption is that the language of the amendment, as recommended in the legislation that has been introduced, would be acceptable to the committee. Again, and that appears on the we note paragraph on page 6. Personnel records created and used solely to evaluate performance. And that, from my perspective, would significantly diminish the ability to withhold so much that, based upon case law, seems to have fallen under the umbrella of Section 50A.
Right. But have a lead in to that. Instead of saying we note that legislation has been introduced, let's have a lead in that signals we're talking about amendment here.
Right. Yeah.
In whatever order is Steve deems to be most
to strengthen
persuasive.
that so that it's more upfront also.
In other words, case law significantly diluted the original intent.
Yeah. And on page 5 at the top, where you've got a sentence that says other have called for the same reform, I would add a sentence that says something more like, the New York Times has called for repeal of 50A in 3 separate editorials in the past year.
Boy, that's great. Thank you.
And then you can go into your 3 editorials. And then you're fine leading into others news organizations have called. And I think then you've got Newsday. In an editorial dated sometime, Newsday referred to the provision as unwise. You don't have a cite for that.
Now I need to find it, so I will.
You need dates for it.
And then the Albany Times Union, I would insert, also called for repeal, stating that the blank outweighed the blank. I didn't get far enough to write that, but I think just put in the body what your thought is, and then lead into the quote in case people don't read the quote well enough.
Can you do me a favor, Franklin?
I can send you these.
Send me a markup.
Yeah, I'll do that.
That would be great.
That's what I meant. I just have some comments here and there that just are
all of you
strengthening the topic sentences so that we signal what we're arguing.
Good. I would appreciate that from all of you, please. And so we can be ready to finalize our report for the next meeting. Is there more on 50A, or should we move on?
I had a comment up at the very beginning.
Yes.
I think we ought to reference our achievements up front. I think I said the same thing the last couple of years. It's been a great year. I mean, so I just would lift something into the first paragraph or have a second paragraph that talks about what a great year it's been. You get into it later in progress, and we got a lot of progress.
Yeah.
You know,
the overview of 2015 is more a history than the accomplishments of 2015.
Mm-hmm. I just like to. I'll think about where it could go, but I'd like to put something up front to say, we made progress again this year, because we did. Getting the Port Authority, that was great, and these 2 pieces of legislation, we want to press the governor to sign them.
Yes, we do.
What I would suggest is I would compliment the support that we received from the governor and the legislature.
Yes.
It's nice to have them with us.
And we can say it's another year in which significant progress has been made, albeit too slow for us, but
It's always too slow for us. Boy, spoken like a true former journalist or attorney for the news media. It's always too slow, and journalists, I know, always want everything.
boy, this is an aside, but I was at a dinner party on Saturday night where the subject turned to how much information there is online. And it's really amazing how the combination of technology and forward-thinking politicians, which I know don't exist everywhere, but we've had a few in New York, have really resulted in huge amounts of information being available.
Franklin, at such cocktail parties, I'm also careful to help people understand the difference between news and information. News being what you need to know in order to plan your future better, and information is everything.
Gee, I could add a couple of comments too. Every year there's some reporter who whimpers and moans and asks, "Is it harder to get information now than it used to be?" And my answer is the same all the time. Have you been to a government agency website lately? In so many instances, you have the ability to acquire both news and information at your fingertips that would have been difficult and perhaps impossible to acquire not so long ago. And the other point, which I think builds upon Steve's comment too, I did a presentation just the other day for the Syracuse Press Club, and there were members of the news media as well as journalism students there. And what I've been suggesting to journalism students is that there is a greater need now for professional journalists who present the news in an objective and accurate way than ever before. Why? Because any idiot can establish a blog or a website, and it's become more important than ever to have confidence in professional journalists who give us the truth. They are truth tellers, and we should be truth seekers. That's my message to journalism students.
What we've done is individualized access to government information. And instead of relying on somebody reporting something, you have said, this is what I want to know, this is how I find it out. And that's the advantage of really what the Department of Health was doing. It was extraordinary.
Yeah, and this relates too to our little section involving proactive disclosure.
Yes.
We've talked in the past about historically, under a Freedom of Information law, the public has had the role of pulling the information out. And with the era of proactive disclosure, the government pushes it out. And in so many instances, that works to the benefit of the public. Of course, I've had this discussion with a professor in China where they push it out. The difficulty is they push out exactly what they want. And absent the ability to continue to attempt to pull it out, we're stuck with what the government wants to give us. So we need both. We need both. We need proactive disclosure, but we also need to continue to have the ability to request information that the government hasn't yet posted on.
Well, and there still remain huge issues with getting timely responses under FOIL. I mean, this legislation I think that we've got will really help, but it is, when you need it right away. And getting the non-statistical information or getting documents you get is still too slow to be of use to community activists who need something, now, or at least in the next 60 days, not in the next year and a half. So
my hope would be that if the legislation is indeed enacted, that will serve as an impetus to government agencies to, let's see, be more serious in many instances about responding to requests promptly. That's the hope. The idea certainly is not to sting the government. The idea is to encourage compliance. Thoughts and comments? Okay. Another area which is discussed on page 7 is also a matter of some controversy. I provide just a touch of history there. Bill probably remembers this because he's been coming to our meetings for an awfully long time. You know, ethics laws in New York have resulted in the creation of various kinds of entities. Formerly the Commission on Public Integrity, now the Joint Commission on Public Ethics. And historically, for whatever the reason, they have been exempt from the coverage of both FOIL and the Open Meetings Law. And that has been the subject of a great deal of criticism. My view is, and it's been the committee's view in the past, that there are sufficient exceptions to rights of access in FOIL, sufficient grounds for entry into executive session under the Open Meetings Law to enable an ethics agency to function effectively. And certainly I think that bringing the existing commission within the coverage of those laws would have the effect of increasing the public's confidence in government. Your thoughts?
What's the rationalization for keeping it out?
You know, that's a good question. What's the rationalization for keeping it out? It seems to me that the rationale, if you will, is to protect privacy, especially in the situation in which so-and-so may be the subject of an unsubstantiated allegation concerning the possibility of misconduct, a conflict of interest, something like that. However, it is clear, based upon case law rendered under FOIL, based upon the grounds for entry into executive session, that kind of information unquestionably either could be withheld unless and until there is a finding of misconduct and or the subject of an executive session. I mean, the Open Meetings Law in particular clearly provides the kind of protection that's necessary. And again, the history in terms of the privacy, if you will, of public employees and others under FOIL is direct, and that is that, and we've seen this in the case of 50A, the fear expressed by police and correction officers, the fear involving disclosure of the unsubstantiated allegation or claim or charge. There's no doubt that records of that nature can be withheld under FOIL. You know, and I think that this kind of recommendation, too, would serve the committee well, as the Committee on Open Government rather than closed government. And, you know, you mentioned what's the rationale. You have an ethics commission, an ethics board, I'm sure, in your county. There may be a similar body in the city of Rome. There are ethics entities all over the state that operate at the municipal level. They have all been subject to FOIL and the Open Meetings Law, and they've survived. There's no reason, in my opinion, why the same kind of application of law, if you will, wouldn't work well at the state level as well. Steve is shaking his head. I don't know if anybody else is.
The only thing I did was put down what you said there. What is the rationale for keeping it out? That is not protected already by FOIL and Open Meetings Law. To me, that would be the first sentence. Or there is no rationale for keeping it out.
Okay. Drop me a line. Also, you know, I pointed out, too, in the fourth paragraph there, one of the real issues that has come up involving JCOPE is the absence of knowledge of how its own members have voted. It seems like a terrible gap in the law to suggest, well, not only are your meetings and records confidential by statute, but we can't even find out how the members vote on an issue?
Judicial decisions are available. If you have a Supreme Court vote, you're going to get how judges voted on it.
Well, that's right.
Why shouldn't this be?
Why should that not be so?
No, this is split.
Basic accountability.
Yes, no, split.
How do our representatives, whether they're from the Senate or the Assembly or someplace else, how did they vote on whatever the issue might be?
Again, I would insert a sentence that describes what JCOPE is, who does it investigate? What does it do? It may be obvious to all of you all, but it's not necessarily obvious to everyone who reads it. Who is it they're investigating?
Except that our audience here is the governor and the legislature, and they certainly know. But
Well, this is a public document.
For the rest of the world, it's probably a good idea just to have a sentence indicating what JCOPE does.
It would help demystify it, I think. Or maybe it makes it clear where the interests lie.
Well, it is mystifying because nothing it does is public. It is mystifying.
Bob?
Yeah.
Rationale, like to see whether at the time they created this, if they stated a rationale for anything?
Didn't look at it. No.
Okay.
You think I should? Do you want to do that?
Yeah.
I'll try and pull that and
Okay.
see, and I'll share it with you when I get it.
The rationale for confidentiality.
You know, because if there's something stated, we should state it and then discuss it.
You know, it has been expressed in the past, and again, the comeback, if you will, is that FOIL and the Open Meetings Law provide the kind of protection that they need to function effectively.
Right, but I'm saying if we're going to
part of
say
the
that there's no rationalization,
Exactly.
I would say, you know, the bill jacket purportedly did.
Okay.
Here's why.
How old is JCOPE?
So that's fine.
JCOPE is only a couple of years
JCOPE
old,
is
right?
new.
It's relatively new.
Yeah, but it was. I mean, it had
A predecessor.
Yeah.
The predecessor was the Commission on Public Integrity, which was created under Spitzer, and that was preceded by another. Of course, at the time, you know, when I shouldn't say this, but when the bill that created the Commission on Public Integrity was passed, you know, the governor's office under Spitzer asked me for comments, and I said, I think that this should be reconsidered because how do you refer to an entity as the Commission on Public Integrity when it's not subject to FOIL or the Open Meetings Law? And I got a call from Governor's Counsel's office that said, take it back. We'll think about it. And of course, they never did.
But that's a really valid point we could make, too. It goes right to the heart of what it does.
Of course. Well, I could do that.
Did they need to include this exception in order to get it passed? Is that what the problem was?
You know, maybe so, but you know, as in so many other situations, it seems that the time, certainly in consideration of what we've seen of late, particularly in the Senate and the Assembly, I don't know that the salesmanship would need to be quite so great.
Yes.
Well, because Silver and Skelos would have opposed this, and now they're gone.
Well, who knows? Now they're gone.
We're not being specific, Franklin.
And there are how many others in the Senate and the Assembly have been either charged or convicted or both? It's a much greater percentage than the public at large. So I don't know that.
I'm going to go with principle, not experience, on this one.
Good. So we'll do a little cleanup on this also. That and the language of 50A really are the areas where there have been significant modifications. The only other one involved the bill that we discussed, or the proposal that we discussed a couple of weeks ago, which is a reconsideration of a prior recommendation that would have required private companies to pay attorney's fees if they sought to block disclosure and lost. And the approach which emanated from meetings that I had with a member of the Assembly and various, let's say, lobbyists, was to offer a different kind of proposal that would require the private companies to move much more quickly in terms of challenging a determination.
Are you
to
talking about
disclose.
D or E here?
I'm talking about.
Page 12.
Well,
Yeah, page 12.
I was back on page 8.
Page 8 is you mean the legislature?
The FOIL should be amended to create a presumption of access to records
Oh.
of state legislature.
Okay. Yeah, that is something that we've recommended in the past.
Yeah, I was just going to say that for clarity, timelessness, and timeliness and economy, I know what's our why. In all of these, for D, E, and the others, we're after clarity, timeliness, and economy in all that we are about. That we want access to information for clarity, for timeliness, and for economy of government.
So what you want to say there, it seems to me, is that fewer records are available from the state legislature than the rest of government.
Right. And later on, when you're talking about the commercial enterprise to renew requests or the changing to 60 days, all of those fall under the very simple idea of clarity, timeliness, and economy.
So if I understand you correctly, what you want to say at the beginning of each of these proposals is, why do we want
Yeah,
this?
this is not convoluted, obscure things. This is just common sense.
Common sense, by the way, is the way that I usually present FOIL when I give a presentation. All the law should really ever say is that everything is open unless disclosure would hurt significantly either somebody in terms of an invasion of privacy, the government in terms of its ability to do its job well on behalf of the public, or on occasion, a private company vis-a-vis its competition.
Yep.
More comments on the recommendations, the substance? Yeah. On page 12?
Yeah.
Yeah.
Going over the principle. I'm not advocating anybody. It just seems like changing that 15 days to 7 just seems awful short.
That's the idea.
Yeah, but you've limited it below, actually.
Thoughts about that, Bill, is saying that at the top of page 13, giving a private company 7 days to determine to go to court may not be fair.
Right, exactly.
Seems a little tight.
Seems
I
a
can't
little
get my
tight.
lawyer
I
to
mean,
call back within 7 days.
Is that right?
Yeah.
That's
So, the rest of it seems fine, but
Yeah.
I would just keep the 15 days.
Is there, should we stat 15?
I think we should keep the 15.
All right. There seems to be, at least around this table, consensus that we should keep the 15.
Is it 15? How does it get interpreted under the law, the number of days? Is it 15, effectively 15 business days?
15 calendar days. There are sections of FOIL. We've lost Buffalo, by the way. There are sections of FOIL which refer to business days. For example, an agency is required to respond in some manner to a request within 5 business days. An appeal has to be determined within 10 business days. In other situations, there's simply reference to days, which would mean calendar days. So this would be 15 days.
And it's clear as is if we stat it.
Yes.
Okay.
Bob, do you know how is this? I just don't have the full law in front of me. How is the service commenced? Is it by mailing allowed, or is it by anything that the CPLR allows for service? I'm just trying to think of the time frames here, because it's you have to actually commence the proceeding within whatever number of days is stated,
Right.
And it's counted for service. So I'm wondering, for instance, it makes a difference, right? Service is simply mailing, and we post something to the company, then they're really losing
3 days.
2 or 3 days right there.
Our advice,
and they've
our
actually gotta
advice,
commence
our
by
advice in
filing.
fairness has been that it's upon their receipt
Okay.
of whatever it may be.
Okay. So that's good to know.
Same thing when you determine an appeal, you have to determine the appeal within 10 business days. You might stick it in the mail on the 10th business days, which means that it'll arrive 12 days later or 12 business days later. Our advice has been that if you stick it 10th business day, you're law, even if the recipient doesn't get the determination till a couple of days later.
So I'm saying, something is could ask them to provide a notice to the agency within 7 days, notice of an intent to file, and then
Yeah, but
commence
that's,
with
I think that going to Bill's comment, that's just as difficult. The idea is that they need more time to think about it.
Yeah.
Okay.
One, Buffalo can still hear us.
We're here.
We're here.
Again, I apologize. We've had
We're
difficulty.
back. Oh, good. Okay.
Have you been able to hear us?
No, we couldn't hear you. Could you hear us?
You missed. No. What have you said?
Okay. Oh, you said all kinds of things.
When did we lose you?
You were
few
just
minutes ago.
wrapping up J-Scope.
Oh, Jacob, what do you think, Hadley?
We were sort of talking about that offline. That well, we were talking about last year's annual report and how nimble you were in sort of jumping on the shift in public sentiment around police personnel files and how smart that was. And it seems like this is sort of the relevant time for this one, given everything that's going on in Albany.
Actually, what you missed is what was expressed. That the time is right and that the task of selling the notion may not be quite as difficult because of what we've seen. In
Oh,
the
absolutely. That's
we
exactly
had-
what we said.
We had the
That's
same
exactly what I said.
conversation while we were
But
waiting to get back online, so we didn't miss anything, I guess.
Well, you know what they say about great minds, right?
Right.
Absolutely.
Was there anything else that we missed in your discussion?
I don't think so.
Okay. What we have done since you left was on page 13. There is a proposal which would give private companies 7 days to determine whether to sue to block the closure, and the consensus was that was too short a time, that it should be 15 days as the law now says.
Okay.
Interestingly too, on page 16.
Are you going to,
Go ahead.
on 13,
Yeah.
where you're talking about the collective bargaining agreement should be accessible?
Yes.
I think you want to make the point that public comment at this point is germane.
Yeah, I think that's why there's been resistance. People are afraid that the public will actually have a clue what's in a collective bargaining agreement and will object,
Yes.
even though those people don't sit at the table and they don't vote on
Well,
the
these
agreement.
people have to face their fears.
Yes, they do. Yes, they do. I think that's a great point. Yeah, I've heard that especially from school districts. Well, if they know, they'll oppose it, and we'll be taking some grief. Well, say la vie. You're going through this page by page. Go ahead.
Well, no, that's it.
I think on page 16, cameras in the courtroom. It seems that the primary opposition to the use of cameras in the courtroom came from Sheldon Silva.
It did. Yeah.
And, again, we know that FOIL and the open meetings law don't apply to the courts, but we've weighed this issue historically. Again, maybe the time is right with a new speaker for an end to this statutory ban. So it's something that I think belongs, again, in this year's report.
Have there been some recent editorials on this subject that we can cite, or has it been so long that people have stopped writing about it?
Yeah, not to my knowledge, and then the other reality is that there are some judges who have opened their courtrooms because of, we just lost Buffalo again, based upon their belief that it's unconstitutional to preclude the use of a camera in a courtroom.
It might be worth looking at what position the Times, the Post, the News, the Times Union, whatever, have taken on this issue.
Wow. That may not be so easy, but we can try.
I don't think it needs it, but it might be persuasive to a new political regime.
Yeah,
I wasn't looking to give you a big job.
Well, I'm going to express apologies on behalf of Diane Kennedy of the New York News Publishers Association, who had planned to be here today, but who couldn't make it. She apologized to you in particular, Steve. But I believe that she will have the ability to locate those editorials, because that has been a subject that's been near and dear to the heart of that organization.
Which decisions indicate that statutory ban is unconstitutional?
There haven't been decisions. There have just been determinations by judges. There are no judicial decisions.
Issuance of several decisions is awful words.
But you've got 45 states where
several decisions indicating that the statutory ban on the use of cameras is unconstitutional.
Oh, that means decisions by judges, not written decisions.
I think that has to be clear.
Okay.
That judges have decided. There needs to be a better way than saying.
Yeah, because it sounds like judicial. It sounds like written decisions.
Yes.
Yeah. Okay.
You've got 45 states in which they've survived judicial scrutiny, right?
Well, yes. Well, not even judicial scrutiny. I mean, the point is that it's statutory in those jurisdictions.
Well, then what you're saying is there have been both judicial decisions and statutory.
Having difficulty getting timely. There we go.
We're talking, I'm sorry again, we were talking about page 16, cameras in the courtroom, and how the language of the court is misleading. It's misleading because there have not been judicial decisions in New York, meaning written decisions, indicating that the statutory ban on the use of cameras is unconstitutional. Rather, judges have, on their own initiative,
right. So
in particular cases.
You have three things that you're saying. One is judicial decisions in other states.
Yep.
Judicial action by several judges in New York State, and statutory decisions in other states.
Yep.
So, I mean, however you phrase it, there are at least advocacy for the position.
The judges that have opined on this in New York, are they saying there's something about the New York Constitution that prohibits it, which is why we're different from every other state, or the federal?
There's legislative opinion.
There's a statute, it's Section 52 of the Civil Rights Law, which was enacted in the 1950s.
Gotcha.
Which and I'll refer to it, I suppose, which says that in any proceeding in which a person is or may be compelled to testify, can't be televised, it can't be recorded.
But that's not constitutional.
It's not constitutional, it's statutory.
No, I'm saying that doesn't provide the basis for a constitutional challenge. That's
well,
a constitutional challenge would be rooted in
First Amendment or something like
the
that.
Constitution, not in a legislative. I'm just wondering if 45 states have passed it, that suggests that it doesn't violate the U.S. Constitution.
That's right. That's right. As a matter of fact, and you as a media lawyer, and you, Steve, maybe are aware that in general, there appears to be no constitutional right to government information. The only constitutional right of which I am aware involves the right to be present during judicial proceedings, which is separate and distinct from the right to bring in a camera if you want to record or broadcast the proceeding. Yes?
I don't know what to say.
You don't know what to say. Yeah, I have to tell people all the time who want to speak during meetings of the city council or the town board, who say, I have a constitutional right to speak. And I have to say, well, you know, your right to be here is statutory. It is not constitutional. You have a right under the Constitution to speak on the steps of City Hall to your heart's content, but you don't necessarily have a constitutional right to speak during a meeting that's held in accordance with the Open Meetings Law.
Well, I agree with Steve's point that we are misleading our first sentence.
Okay. Yeah.
We give too much
judicial
credence
actions
to
is
these
better than-
judges.
Yeah, actions is better than decisions, and I will revise it accordingly. Thank you. More comments? How about our you know, this was a pretty active year. We developed our list of presentations.
That immediately, I looked on page 16 where it says I see the V and see J. In other words, I see, wait a minute, we're just leading on to another example. Services rendered by the committee is terribly important and deserves a new section or a new page.
Okay.
And
That
then
was,
I'm confused by the substance. And it wasn't clarified by what followed. You've got 4,444 telephone inquiries, a shocking number, both in the fact that it includes 4 fours. And I don't see how you all get any work done taking this many phone inquiries.
It is difficult.
Amazing.
That's why I'm so glad that Kristen is here.
She's going to take on 1,111 of them.
That would be later on, but for the time being, she's going through our stack of requests for written opinions, and we're trying to move ahead on that so that yes, we can become more efficient.
Now, where I got confused under that was I expected the next statistic to be how many email inquiries you've gotten, and instead what you give us is 795 email responses. And that wasn't clear to me whether that was in response to email inquiries or in response to telephone inquiries. I wasn't sure how they related, and the same with the advisory opinions. And when I looked to the text, it was clear as mud.
Thank you for that.
On page 18, you've got your 4,444, and then down under via email and written correspondence, again, I couldn't find the number of email requests you got as opposed to telephone requests. And maybe you don't have that number.
I can explain, and we probably don't. The telephone inquiries, it seems to me that that's pretty obvious. The phone rings, we pick it up. Email now, we get, and I tried to sort of divide the email between those situations in which somebody drops us a line and we can respond in 2 sentences. Now, we used to count those as advisory opinions because they were, in a way, but now if I can respond in 2 sentences, I do that, and often the response will involve something to the effect that attached is an advisory opinion that is responsive to your inquiry. It is simply much more efficient. That would be the kind of email response that is referenced here under number 795. Now, in some cases, instead of getting a letter that is 3 pages long that comes through the U.S. mail, we get email, which is exactly the same thing. It is simply a different means of transmitting a request for an advisory opinion, and they would be included within the 121 advisory opinions. Both the United States So the 121 advisory opinions represent responses that are significantly more detailed than the email responses numbering 795. It didn't quite know how to provide that in a different way.
How many email inquiries have you gotten that would correspond to the 4,400 telephone inquiries? I mean, 1,000?
None of those are
795?
email. None of those are email. Out of the 44, no, that all involves the phone ringing.
Yeah, what I'm wondering is how many times does your how many email inquiries do you get that result in your 795?
Oh, I'm not including spam.
Not including spam. And not including your board members.
Speak.
I mean, isn't that a number like 1,000 or 1,500 or?
We received 608 email requests and 186 written requests. So we just added those numbers together.
Yeah, they both would be written. Okay, so that's how you get to your 795.
That's correct.
Do you never respond to telephone inquiries with an email response?
Sometimes we do. If I'm on the phone, I'll ask for, I did it this morning, what's your email address, and I'll send a copy of an advisory opinion from our website. But otherwise, I think that it becomes too complicated. I wouldn't characterize that as an email response. It was a verbal response that was enhanced, if you will, by sending a copy of an opinion.
Right. Nor do you track the number of search requests.
Oh, we used to be able to track the number of search requests, but it seems that we no longer have the ability to do that, or at least the Department of State is not willing to spend the money to prepare something like that. Do you remember we used to do that, Bill, where we were able to get a breakdown of the number of email searches and which searches, let's say, were most popular.
Mm-hmm. That's a very appealing, useful tool.
Oh, I love it, but don't seem to be able to do that.
I should think that the Department of State would be interested in that for their own use.
Maybe. We were told a few years ago that is just too costly and time-consuming.
Not having it is costly and time-consuming. I'm advocating for it.
It's the Rolling Stones principle of law. You can't always get what you want. I've said that too many times, but yeah, that would really be interesting. You know, the last time we did it, it seemed, and I'm positive that we received more than 1 million hits on our website annually.
Those are spammers harvesting email addresses.
No, you know,
As a records access officer, I
It was probably
1,000 times.
probably
would go there 1,000 times, and you know, when I do a presentation now, I always ask the crowd, you know, how many of you are from the committee? You know, most people raise their hands. How many of you have gone to our website? And you see, almost every hand go up. You know, and I've mentioned this before. FOIL has become part of the language. People know about it. And you can go online and just Google FOIL, and you'll be at our website. It's probably the third item down. So people use the website with impunity, which makes me feel good.
May I point out something, if you don't mind?
Sure.
I'm looking at the pie chart on emails by writer, and this is just a suggestion, but I think that when you first look at it, I think the colors for state legislature and public are just too close to be next to each other. Maybe, you know, one would be yellow or whatever, but I just think if somebody's just looking at it and they're trying to make a reasonable, quick assessment, that will make it clearer. And if you don't mind, I'm going to go back to page 4 where I had a question, but we kind of moved along and then we got cut off.
Good.
That first paragraph on page 4, that second sentence, the number of users of the site increased from 2.3 million to 6 million. At what time was it 2.3? Because the previous sentence says it was, he was announcing the launch of the official New York State website, but then we get to a point where there's a 2.3 million. I think that's not clear.
I'm going to have to look at the governor's press release to answer the question, but it's a good question.
Okay.
Check this.
Good comment. Now, but back to this list on page 16. Do you respond to email with email? So if you had 608 email requests, you have 608 email responses, right?
In all likelihood, yes.
Then you've had 186 written requests. What does the 121 advisory opinions relate to? Do those go out by email, or are those in response to written?
Either or both. Those are, again, the let's call them the lengthier responses to inquiries. Creative, maybe precedential, but not the 3-sentence response.
Are they newly created?
Yes, they're newly created.
So how do you respond to 186 written requests? Do you call people? I'm just trying to get the numbers parallel here.
We do all of that. We do all of that. I mean, there are so many situations where you receive either something in the mail, the old-fashioned mail, or via email, where it's easy to pick up the phone and give a response, or, again, to send a copy of an existing opinion.
Well, suppose we say there are 795 written inquiries and responses.
Well, but email is in writing.
That's what I'm saying. Delete email and just say written response inquiries. What I'm missing is inquiries from that line.
Yep, there's no differentiation.
I see what you're saying. What if we were to say 795 email responses to inquiries or something like that?
Well, inquiries and responses. Well, why don't you just say written, since that 795 also includes letters?
Yeah, responses to written requests or written inquiries.
I was going to say 795 written inquiries and responses.
I think Bill had a good idea. Could you repeat that?
Responses to written inquiries.
795 email responses to written inquiries.
But I do think the point is, we had this conversation the other day. I brought it up too because I noticed the numbers didn't seem to match. Is that we're not always responding by email. So if we're just being accurate, I mean,
that's why I was just going to lump them all under written.
Right.
Unless you want to make the point that they're email.
Yeah. So
including email.
Responses to written or emailed requests.
The difference in that they're brief responses as opposed to the advice.
Yeah, well, that's part of the point. That's part of the point, and I tried to make it. Where do we do that? Yeah, they are. You know, Bill is suggesting the 795 are largely informal responses.
Differentiated from advisory opinions.
Differentiated from, right. Yes, from the newly created opinion.
Then who cares whether they're emailed or snail mailed?
I guess. Right. Well, that's the question, I suppose. Is there any reason for distinguishing the two?
Informal response.
You could put a sentence later under C. Oh, you've got it under C. No, you don't. You don't have the two numbers you just gave us, the 608 and the 186.
I did refer to detailed written opinions.
Right, but the two numbers you just gave us, 608 email requests and 186 written, you could put that on page 18 under C. Assistance via email and written correspondence.
We could do that. Candace,
Just
you
add a
got that?
sentence there.
Okay. Candace is following this along so she can make the appropriate changes.
Why don't you just say parcel?
A passel of
A
yes.
passel.
A passel. Because
And
nobody
I
will
like-
understand it, Steve. Nobody will understand it.
I'd also like to add to your little list up here your email, your website hits, because that's an amazing number.
It is.
Can we put it under the 4,500 plus trained?
But I don't know the number of website hits.
Over 1 million.
Well, that's yes. It would be non-specific. Let's put it
I
that
don't
way.
mind that. I think that's an amazing way in which we help people.
Yeah, what you're really saying is the fact that the website is a great help.
Yeah, it is, and it's heavily used.
Right.
It's heavily used. And in fact, I have said also that our website is easy to find. You just Google COOG because we seem to be the only committee on open government in the world. Or you could Google FOIL, or you could Google my name, and you'll get to our website. And maybe that's something that we could sort of throw in. What do you think?
But I think the number of hits is really an amazing statistic for an agency that has 2 employees.
Well, we're up to 3. We're up to 3 now.
3 employees.
My question is, and this is Jean, I'm wondering, is it important to distinguish between telephone requests and email requests and snail mail requests? Isn't there just a total number of requests that's impressive?
It is, but I think it's important for the public to know and for others to know that they can pick up the phone and call. And my personal belief is that the best and most important thing that we do is pick up the phone. If we can answer a question, resolve a problem before it becomes a dispute instantly, I think that that's the best kind of government. So I've always thought that reference to our phone inquiries has been important and telling.
It's dynamic and immediate.
Yeah.
Particularly,
I agree.
It's also time consuming.
Right,
Yes.
I agree, but when you're looking at your numbers, I'm not sure that it makes. I think that you can say that. That can be stated. That information can be there, but it could be defined as including telephone, email, and mail and postal requests. I'm not sure that when you look at this, the pie charts, that it makes that much. I don't think the pie chart says, we have 3 people answering the phones for, all of these calls. But I do understand the point that you're making. It just seems like when you start to look at the numbers and they don't add up, you start to question. You start to question it more.
Gene, I think you're saying something interesting, that an easier way to get into or to draw people into what's happening here is to explain the kinds of services that we offer. We are available on the telephone and for immediate discussion of these things. We're available by email and regular mail to offer more detailed, specific answers to questions. We offer advisory opinions, and we have a very comprehensive website. And that's a summary at the outset that says, we do a lot of critical analysis, or provide a lot of critical services in a variety of different ways.
Sure.
I agree.
Right. Correct.
So that would be
6,000 inquiries. That's amazing.
So
Almost
that would be
6,000.
Don't lead with the table, lead with an explanation.
So you want that as the first paragraph on the top of page 17.
Yeah.
Well, I put it at the bottom of page 16.
Well, it's the same thing.
Well, but the table is not what you're. What's impressive to me is the description of what you do, the variety of, yeah.
Okay.
The table is just supporting information.
Okay. Sure. Fine. You taking notes? Good.
What you do is so impressive. You're also the most famous man in America, Bob.
Jesus. Give me a break.
I'll mention
Well, you know-
Coog, and I get this blank look, and then I'll say Bob Freeman, and everyone I know goes, "Oh, Bob Freeman." Everyone knows you.
41 years. I've spoken to half the people in the state at least once.
And they remember.
It seems to be
it's
getting
more shocking.
It's getting closer and closer to the truth. But thank you, the most famous person. And where does it get me? You know, you're reminding me of something else, how public officials are nervous about seeing their names in print, seeing their faces on the tube. And, you know, I do some TV, and I took the bus for 25 years, and I'm a walker, and people say, "Hey, Bob, I saw you on TV the other day." I always ask them the same thing. "What'd you think about what I said?" And they always say the same thing. "I don't know what you said, but you know you look good." So,
Are you coming back down this way anytime soon?
Not so sure. Let me see, New York City. Well, I am going to a luncheon at the Plaza Hotel on December the 1st. Maybe I should fill you in on this for what it's worth. I've done some work with what is called the International Senior Lawyers Project, which is a not-for-profit that is geared toward the improvement of and establishment of positive laws involving news media around the world. And, you know, I've written a couple of articles and did a presentation in Washington. Well, they are having an awards luncheon at the Plaza. And the fellow with whom I've been dealing, Dick Winfield, I don't know if that's a name that anybody knows. He will be recognized, and I've been working with him for years. And he was with Rogers and Wells for a long time. The keynote speaker is a guy that I met in 1965. And I'll go up to him and I'll say, "I remember you. Do you remember me?" Bill Clinton. He'll be the keynote. And I'm taking the day off. I've never done this before. It's $250 to go to lunch. And my wife, I said, $250. She said, "You're crazy." And then I said, "Bill Clinton is going to be the keynote speaker." And she said, "I'll go too." So, yes, and the outfit for New York City and the transportation will probably cost more than the ticket, but what the hell, right? Why not? So we'll be at the Plaza. We'll be at the Plaza on December the 1st.
Well, I want to come when you give the keynotes.
Doing a program for the New York CLE program for the Trial Lawyers Association in January.
Let me know when and where that is. I'll come
Okay,
listen.
I will. I don't know where yet, but I think it's January the 13th, and I'll let you know when I find out where it's going to be. So, are we set? Are we set? Are we directed to prepare a final version of this report to be reviewed and adopted? Thank you. On when's our next meeting, Candace?
December 8th.
December the 8th. No, it's not December the 8th. Please. December the 10th. December the 10th. December 8th, I know I'll be speaking in Corning, New York. Does it get better than that? Corning in December?
So that's going to be Black Line.
At 12:30.
Right, so
At 12:30. 12:30,
It's
December 10th.
beautiful in December. It's already.
Okay, and Bill suggested
I would have
that.
been here at 10:30 doing
So
a dark room.
you want us to bold the changes? We'll bold the changes or something like that so that they can be
Edit
followed
marks
more
on the
effectively.
side, yeah.
Edit marks on the side, something like that.
Track change.
Yeah.
Okay.
Can we do that before the 10th so that we have another turnaround before our next meeting?
You mean, can I get it to you before the 10th, or should we have another meeting?
No, can we have another turnaround before the 10th so that we have a very clean version on the 10th?
Yeah, you get it to us a few days before.
Oh,
the
of course
10th.
I'll get it
That
to you a
way-
few days before the 10th.
That way
Of
we can
course.
all get our comments in.
Yes, of
See
course.
the final version beforehand.
Yeah, I'll try to get it to you several days before the 10th. No promises, but several days. Good. Well, then thank you all.